Hi, my name's Greg Wagman. I'm an attorney here in New London, Connecticut. I've been practicing law since 1992. One of the areas I focused on is helping people when they get in trouble with debt. We try to help people make the best decision about their situation. Many times a bankruptcy is the best decision, the quickest, easiest, cheapest way to get a fresh start. But other times bankruptcy is not appropriate. So what do you do in those situations? One of the things that happens in those situations is when you're having trouble making monthly payments on your bills, when the debt collectors are calling incessantly, when you're being sued for the debts being owed, or when your foreclosure or repossession is coming up. Um, those are the things we help people with when they come in. We try to analyze their situation and then give them kind of a roadmap of the things they can do. So today we're briefly going to touch on the topics of stopping the creditor calls, stopping or forestalling a foreclosure, or at least understand what the process is so you know what your timeline is. Um, Debt, how do you get debt relief? Assess the collections and repossession, repair, restore your credit, dispute your credit report, and bankruptcy is always an option in your back pocket. After you've started to miss minimum monthly payments, the debt collectors will start to call, and everybody knows that they will start to call all the time. But they have rules. They can and can't do certain things. The Fair Debt Collection Practices Act says that they can't use abusive or obscene language. You know what? If somebody's yelling at you like that on the phone, hang up. You know, you don't have to listen to that. My staff are specifically instructed that if anybody is abusive to them, they hang up. Life's too short for that. Repeated calls after you told them to stop, especially if you're at work. Calling before 8 a.m. or after 9 p.m. unless you told them to, unless you're on third shift, you don't want it, and you want to be called at 7 a.m. Fine. But other than that, no, they aren't allowed to. They aren't allowed to call you at your job, especially if your employer doesn't allow those types of phone calls, and most don't. I mean, why does the employer want to pay for your time to talk to debt collectors? They aren't allowed to talk to family or neighbors or anybody else about your debt. They can't call. They they can and will call your family and say, "Do you know where Joe Smith is?" But they can't talk to them about the debt, and that's why when they leave a message on an answering machine, they say, "Please call us back at such and such a number," but they don't leave a message about the debt. They can't misrepresent the amount of your debt. They cannot claim to be a lawyer or police officer unless they actually are a lawyer or police officer. In some states, the police departments are more aggressive about helping businesses collect debts. Not as much in Connecticut, although it can happen. Falsely claiming to be a lawyer, again, is a violation of the Fair Debt Collection Practices Act, but there are some lawyers that do debt collections. But normally it's staff that calls, so they can say that they're from the particular law office. And just as a quick aside here, if you're getting letters from attorney, if you're a Connecticut resident or whatever state you're a resident of, you're getting letters from Arizona, from California, Chicago, whatever, doesn't matter. They have to be a lawyer licensed in Connecticut to be able to sue you in Connecticut, and they have to sue you in Connecticut where you live. They can't claim to be a part of the credit reporting bureaus, Equifax, Experian, or TransUnion. They're not allowed to claim they're part of those businesses, but they can say, we will report this to the credit reporting bureaus. They can't threaten to sue you if they don't intend to sue you. Kind of hard to prove, but you can always try and call their bluff on it. I mean, if it's somebody from out of town or out of state, they do have to get a Connecticut attorney to sue. They cannot threaten any type of physical harm, obviously, and you might even want to report that to the police department if you know where they're calling from, if you can track that down. They can't threaten to have you arrested or put in jail. It's very limited circumstances in which a debt collector can put you in jail. To put you in jail, they have to have sued you. They have to have gotten a judgment. They have to have filed with the court what's called an EJD, an examination of judgment debtor. And if you don't show for that, they then can ask the court, they can subpoena you to that particular EJD. And if you get a subpoena to court for a debt collection action and you ignore a subpoena, especially, and then the subpoena will have to be served to you in hand. In other words, a marshal will have to hand it to you. And then you ignore that, that can get you put in jail. Won't be for very long, be long enough until the next court date, and they will then get you in front of a judge on the next court date. And the judge will make some sort of arrangement. So you can't ignore a court order. A subpoena is a court order to be in a certain place in a certain time. And those can be issued by attorneys. They don't necessarily have to come directly from the court. What not to do when you're dealing with debt collectors. Don't get into the argument. Don't play their games. It's not worth it. Just hang up. Don't lose your temper. Not worth it. Again, it's not going to buy you anything. And you may say something you wish you didn't. And some of these calls may have been recorded. And it's just not worth your time, actually. Don't admit you owe the debt or are aware of the debt in question. Ask them to send you information regarding it. They tell them you want something in writing. They have 30 days to send you something in writing. Do not ever give out your social security number. Anybody that calls you out of the blue, if you're not expecting a call or you don't have a prior relationship with any particular business, you shouldn't be giving that information out anyway. Don't provide any of your income information or bank information. They don't need to know any of that. If they want to know that stuff, there are court-approved processes to get that information from you. They can send you interrogatories, that sort of stuff. Not provide information about property you own. That all gives them ammunition to do things that aren't going to help you. Don't send in partial payments. One of their best little tricks is, because I mean, really think about it. You're feeling bad that you can't pay these bills to start with, right? I mean, everybody wants to pay their bills. So they say, well, just send us $10. Show us your good faith. That resets a statute of limitations. So in Connecticut, the statute of limitations is 6 years on a contract action, on a debt collection for a contract action. You have just started the 6-year clock again. And many of these people start calling it year 4, year 5. So you never send in a partial payment. Some people want to negotiate their own payback arrangements. It's usually more effective to have an attorney do it for you, and I'll tell you why. Because basically, I say to the debt collector, "Here's what my client has. We can get it to you by Friday or next week, early next week. You know, we'll FedEx you a check or we'll wire it." And they're like, "Well, that's not enough." I'm like, "Well, then sue my client because I'll make more money when you sue my client." And they're like, "Oh, well, let me go talk to the manager." So that's how an attorney has a little bit more leverage. And again, you know, debt collectors are more interested in getting some money in and getting the case wrapped up because they get paid by how much they've collected. So make the debt collector prove that it's your debt. Make them show that they are authorized to collect that particular debt or that they own the debt. These debts get sold off by the thousands. They literally bundle them into big packages and sell them from collector to collector. That doesn't necessarily mean that your particular debt was involved in that particular bundle. And so they have to show that they actually own the debt and how that debt arose. Just hang up. Being rude is not something you should worry about in this situation. So the next step after the debt collectors decide that you're worth trying to collect against, but they're tired of calling, they can sue you. Always reply to the lawsuit. Never ignore anything coming from court. There's nothing good for you going to come out of ignoring it. What normally happens is you just lose. You lose, and then now they have a judgment. After that judgment gets to a certain age, you have very, very, very limited ability to reopen that and try to go back and change things. It's very difficult. So don't ignore it, because they will just get a judgment, and then once they have the judgment, they can take money straight out of your bank account, They can garnish your wages. They can take 25 in Connecticut. They can take 25% of your net income, and they can also put a lien on any property that you own. Any property that your name is on, even if you don't really own it, but it's say your parents put you on for inheritance purposes. They can put a lien on that property. That means if you go to sell or refinance, you're going to have issues trying to get that done. What you should do is to be informed, understand what your rights are, stay calm, keep good records of who's calling and when they're calling, because if they're violating the act, then you have some recourse. If you do make a deal with any kind of debt collector, get it in writing before they get any money. You want in writing what the terms of the deal are, because these things get sold off and they get sold off from one to another. And if your debt gets bundled into the bundle that gets sold off to the next debt collector, it becomes what we call zombie debt. You now have another debt collector. You're saying, but wait, I paid that one off. And if you don't have a good paper trail for that, it's useless. And now they're bugging you again because they think they can get some money out of you. Never volunteer unnecessary information. It's socially, we want to talk to people, we want to chat with them. It's the less you say, the better. If you can come up with an equitable solution, again, get it in writing and make sure you perform your portion of it. Treat it all as if it is going to go to court, because if it does go to court, you may be able to use that as some defenses, or at least some mitigation while you're in court. If you can't do it by yourself, definitely get an attorney involved, because we do this for a living. So we've seen all the stuff, and it's much easier, and we can tell you what's going to work and what's not going to work. Because if you ignore it, you no longer have an ability to put your defenses in there, and you may have good defenses. The contractor never finished the job, or the credit card wasn't yours, it was taken out in your daughter's name, or you have you're a junior and a senior kind of thing. There's a gazillion different things you need to look at to make sure that A, it really is your debt, and B, should you really be paying it? This happens a lot too with medical debt, when the insurance companies are supposed to cover something and don't. So if somebody from a medical debt sues you and you don't challenge it, you lose your chance to even present that evidence to the court. Sometimes the debt isn't calculated correctly, so that's another thing. So they're saying you owe $10,000 when it really ought to be $27.95. Because you made payments to this prior debt collector or whatever. Again, keeping track of everything is very important. Again, owning the debt. The creditor has to own the debt. They have to have standing in court in order to actually sue you. They have to have a good reason and properly own the debt before they're allowed to sue you. The statute of limitations. They can still sue you even though the statute of limitations has expired. We've gone past the 6 years since the date of last payment. That's the statute of limitations for contract actions in Connecticut. If they can sue you after the 6 years, and all you have to say to the judge is, Judge, the last time I made a payment on this thing was more than 6 years ago. He then looks to the other side and says, is that true? And that the other side then has to show it's true, what their records particularly show. But they can sue you even though the statute of limitations has expired. Respond to the suit. Don't ignore it. Do not stick it on the kitchen counter and say, I'm going to get to this sometime later. There will be a date on the suit. In the top right-hand corner of a Superior Court suit, it's called a return date. That's the date in which the plaintiff has to have their paperwork into the court 6 days before that particular date. You have to file an appearance with the court at or around that date, within 2 days of that date, although the courts are a little lenient with that as far as, if you filed a week late, that you're going to be okay. But an appearance form, so if you read that form from Connecticut courts, it says you must file an appearance with the court within 2 days of the return date. Appearance is just a piece of paper that just has your name and address on it and says, I want everything that happens in this case to be sent to this particular address. You don't have, there is not a court date that day. You will not be in front of a judge on that day. The other side will not be there on that day. It's just a piece of paper that has to get filed with the court. And it can be filed electronically if you sign up for electronic filing, or you can file it by fax, or you can mail it, or you can go to the courthouse and fill one out. And they're right on the Connecticut judicial website is where you can find those. You file that appearance. In a small claims case, you have to file an answer. And then again, in that answer, don't admit things that you don't know. So when Midland Financing sues you in small claims court, well, Midland is a big debt collector. They buy up debts from all over the place, all kinds of credit card debt. They buy it up for pennies on the dollar, and then they sue the clients. You've never dealt with Midland. You've never taken any debt from Midland. You never borrowed anything. You probably don't even know who Midland is unless you're an attorney who does debt collection. So don't admit that you owe the debt. Let them prove it. Let them show the judge that they have the actual authority to be collecting on this debt. Once the creditor gets a judgment, again, they can garnish your wages up to 25% of your net income. They send a form to your employer, and your employer must send them that money. Your employer does not have a choice. So don't go to your employer and saying, "Oh, don't send it, don't send." Your employer is violating the law then if he or she doesn't send it. And I don't know why they would want to put themselves in harm's way for you. Normally they don't. They can put a lien on any real property that has your name on it, and they can take money out of any bank account that has your name on it. So if it's your child's account, they can take the money out of there. If you're on the bank account with mom or dad to help them take care of their bills because they're getting older, they can hit that account. So or any joint account with your spouse. The only exceptions that is Social Security payments. They are not allowed to take up to 2 months worth of Social Security. The bank's not even allowed to let them touch it. But if it's any kind of wages in there or any other type of funds that are commingled with Social Security, they'll freeze the account. Then you got to go to court, get the judge to say, well, this much is Social Security, this much isn't Social Security. Well, meanwhile, that's 45 or 60 days later. So I don't know there aren't many people. If you're in this situation where you have debt collectors calling you, you don't have 45 or 60 days worth of extra money sitting around, is my guess. Again, so if the creditors are calling you, follow our tips on do's and don'ts. Call us. We'll give a free consultation. Come on in. We'll look at your situation. I'll say, here's what you should do. Here's what you shouldn't do. And then you can decide whether or not it's worth hiring us. It may be for some people. It's not for other people. I'll tell you that actually. If the bankruptcy is an option, don't be afraid of bankruptcy. Over 800,000 people file every year. I'm sure you know somebody who has filed for bankruptcy. You just don't know that they filed. Their lifestyle, you didn't see a change in their lifestyle. You didn't. Most people keep their cars. Most people keep their houses and get rid of their unsecured debt in most situations. It doesn't kill your credit score for life. You can get credit the day after the bankruptcy is finished or discharged. And so bankruptcy is a very, very strong option. In fact, it's so strong that it's written into our Constitution. But be prepared and informed before you need it, before you start getting lawsuits. Come in and see us, and we'll tell you what's going to happen, how it's going to happen, and what you should be afraid of and what you shouldn't be afraid of. So just give us a call or email us, and we'll be happy to help you out. Thank you.